in international economic law here. But before I introduce her, perhaps I should just say something about the lecture we are about to listen today in the Gillian White lecture. Who was Gillian White? Very briefly, Gillian came to Manchester in 1967 after spending, I think it was 6 years at Cambridge. And in 1975, she became the first woman to be a professor of international law in the UK. And that was unique because in those days, I think women were seen as more intelligent than men, but they couldn't become professors. Yeah, so unfortunately, yeah. So, Gillian was stayed in Manchester from 1967 till 1991 when she retired and moved to Australia to meet her husband. But unfortunately, in 2016, I remember, 2016, that Gillian passed away, and the School of Law introduced this annual lecture in her honor. The first annual lecture was delivered by Professor Mary Footer at the University of Cambridge, and that was at the University of Nottingham, sorry, and that was in 2017. And then the second one was delivered by Professor Laurent Boisson de Chazon from the University of Geneva, and these are all top personality in international economic law. Gillian was, in fact, a professor of international law, but her area of research was mostly international economic law. But because international economic law was at that time seen more as economic things, area of law that should be dealt with by economy, it was not even considered as law. So she could not have that title of international economic law professor. So she was professor of international law. But anyway, and today we have the pleasure of having Professor Andrea Bjorklund as our third annual lecturer, the Gillian White lecturer. And the topic of lecture will be the dispute settlement minuet between trade and investment. I think I don't have to say very much about the context of this the lecture because it's a very topical issue now. But I will just talk a bit about the background of Professor Bjorklund. Professor Bjorklund is a full professor and the L.If. Fortier Chair in International Arbitration and International Commercial Law at McGill University, Faculty of Law. That's in Canada, Montreal. And in 2017, she was named one of McGill's Northern Rose Fulbright Scholars in International Arbitration and International Commercial Law. In winter 2018, she was a Plummer Fellow at St. Anne's College and a visiting fellow in the law faculty, University of Oxford. So, and in addition to serving as an advisor to the American Law Institute's project on restating the U.S. law of international commercial arbitration, she is a member of the advisory board of the Investment Treaty Forum of the British Institute of International Comparative Law. Professor Bjorklund was the inaugural ICSID scholar in that's International Center for the Settlement of Investment Dispute, scholar in residence for 2014-2015. I'm talking about McGill, and was editor-in-chief of the Yearbook on International Investment Law and Policy, published by OUP from 2012 to 2015. So she also sits on the panel of arbitrators of the American Arbitration Association, the International Center for Dispute Resolution, and on the NAFTA Chapter 19 arbitrators. The profile of Andrea Bjorklund is really long, and I don't think we'll listen until tomorrow here about her profile, but it's just worth mentioning that she's written a lot in the area of international arbitration. And some of her books include the international investment law and soft law, the interaction between soft law and international investment law. And that was published in 2012 by Elgar. And then also international investment law and arbitration, the cases, materials, and commentary. I'm sure the book, when you see it, is frightening because it's about 700 and something pages. And then editor, the yearbook on international investment law and policy. So please, can we put our hands together for Professor Bjorklund?
Thank you very much. I'm really honored to be here and to be asked to give the third annual Gillian White Lecture. As you've heard, she was the first woman appointed professor of law in Great Britain and the first to be appointed as professor of international law in the United Kingdom. This appointment happened in 1975 when I was 10 years old. I cannot pretend to have known this at the time. I didn't even know what international law was, but I'm really the grateful beneficiary of women like Professor White, who created a path for women to follow and who served as role models for younger women. Because she was a proponent of a rules-based legal order, I'd like to think Professor White would find my topic today to be stimulating, albeit possibly a little bit depressing as well. I've entitled my talk, The Dispute Settlement Minuet Between Trade and Investment. Minuet is a dance characterized by small steps. I realized, I had to choose something when Professor Hodu called and said, "What is the title of your talk?" I might just as well have described it as something of a funhouse mirror between trade and investment, where you have some reflections that seem distorted, and some thought that perhaps these two regimes don't learn very much from each other. But we'll see as the talk progresses whether you think it's more of a dance or more of a joke from the funhouse. My inspiration really came from the rather oddly divergent situation we currently see. On the one hand, the World Trade Organization's crown jewel, the dispute settlement body with its appellate body at the apex, is in crisis. If the impasse on appointments to the appellate body is not resolved, the appellate body will lose its ability to function at the end of 2019, and possibly earlier if any one of the appellate body members has to recuse himself in any particular case. If that happens, the most likely alternative to traditional WTO dispute the traditional WTO dispute settlement mechanism is likely to be arbitration under Article 25 of the Dispute Settlement Understanding. On the other hand, investment treaty arbitration is currently under attack. It's under attack for being illegitimate, for lacking consistency, for lacking coherence, for having judges, for having arbitrators appointed in individual cases. The most likely alternative to investment arbitration, and the one most strongly sought by the European Commission, is a multilateral investment court with an appellate body at its apex. So on the one hand, in one place we've got the thought that the appellate body is not doing well and needs to be replaced. On the other hand, and it would be replaced by arbitration. On the other hand, we say, oh, arbitration isn't doing very well. We need an appellate body. How is this happening? What explains this odd situation? It's clear that the European Commission's proposal for a multilateral investment court, often called a MIC, M-I-C, is drawn in part from what had been viewed until lately as the successes of the WTO dispute settlement mechanism. Yet you could also argue that investment arbitration could be viewed as a success, even though it's been criticized for a lack of legitimacy. More than one commentator has effectively described ascribe the criticism of investment arbitration to envy. In other words, people are criticizing it because it's working so well, because people are using it, because people find it attractive. So one reason for the disparity in approach to trade and investment is fragmentation, that friend or sometimes that foe of international lawyers. They are often regarded as occupying separate spheres. Even though people might suggest borrowing from one to another, from trade to investment, from investment to trade, that borrowing usually occurs on a piecemeal basis. So the idea of an appellate body has migrated from the WTO context to the investment context, but that migration hasn't necessarily brought all aspects of the WTO appellate body with it, or of the WTO's grander dispute settlement mechanism. That means it hasn't brought positive things, as well as not having brought negative things. It also isn't clear that we draw appropriate lessons from one thing to another. Once you take something out of context, you tend to deracinate it. You take it away from its roots. It's easy to look at it in isolation and not to realize that it really comes with a lot of baggage with it. And I'll be talking a little bit more about that when I talk about the criticisms that are currently levied against the WTO appellate body. And I apologize for my cold, but I feel fine. I just can't talk very well. A second reason for this disparity, I think, is a deep-seated ambivalence on the part of most states towards international dispute settlement. Remember that the WTO dispute settlement understanding was finalized only after nearly 50 years of dissatisfaction with the Gatt panel model. So it took 50 years to try to fix what was wrong with Gatt. In fact, I would argue to you that the more judicialized a dispute settlement mechanism is, the more likely states are to be skeptical about it. And in this talk, I want to elaborate a little bit on this ambivalence and why I think that the more dispute settlement mechanism veers towards a model of global governance, the more likely states are to disparage it. I've divided my talk into the traditional three parts. First, I'll talk a little bit about legalization, kind of the first stage in judicialization of dispute settlement, and that leads to rules-based dispute settlement with cases decided by some kind of neutral quasi-judicial decision maker in both trade and investment, drawing a few parallels and distinctions between them. Second, I'll talk a little bit more about judicialization, the sort of establishment of judicial or quasi-judicial dispute settlement. And then third, I'll say just a few words about constitutionalization, the placement of international judicial institutions into a constitutional or quasi-constitutional order. There's overlap in these three areas, to be sure, and each does build a little bit upon the other. But the early and mid-20th century is when we saw slow steps towards the legalization of dispute settlement in both trade and investment. So when we think about legalization, in order to have rules-based dispute settlement, you need rules so that the dispute can be settled on legal grounds, as well as a venue in which to settle them, a place where a neutral decision maker applies the law to the facts of a particular case. Yet often, and we've seen this particularly, we see this in both investment and trade, we see a divorce between the legal order and the dispute settlement framework. Sometimes this is pragmatic. It can be easier to get agreement on dispute settlement options than on the rules themselves, or the other way around. We also see some tension between multilateralization and bilateralization or plurilateralization. It can be easier, the fewer parties you have, the easier it can be to come to an agreement. So we have on occasion in the 20th century seen the goal of a grand multilateral solution replaced by more modest bilateral or plurilateral options. And again, this has happened in both trade and investment. In the investment arena, attempts to have a multilateral rules-based instrument started as early as the 1920s with the Harvard research on the law of state responsibility, followed by the International Law Commission's attempts to finalize rules on state responsibility for injuries to aliens. That's what kind of trade and investment law was called in the late 19th and early 20th century. Some of you, if you've taken international law, you might know that we now finally have International Law Commission rules on state responsibility. What you might not know is that the scope of those rules, of those articles, is much less ambitious than when they started the project in the 1930s. So they wound up limiting the scope in order to get some kind of agreement. So it's a much less ambitious project than the initial projects were. In addition, we had the ILC working to try to have a multilateral agreement on investment. Germany and to try to codify international investment law. Germany and the United Kingdom tried to establish a multilateral instrument, which was called the Abs-Shawcross Convention in the late 1950s. And the Organization for Economic Cooperation and Development, the OECD, built on that in 1960. Each of those would have had arbitration as a means of dispute settlement, although the Abs-Shawcross Convention would have required agreement on an individual basis, with the International Court of Justice as the default. Both of these attempts failed, so you really had this strong push to multilateralism in the investment arena. In the middle of the 20th century, they were not successful. What we saw in response was in 1959, the drafting of the first bilateral investment treaty, as sort of less ambitious, a smaller attempt to establish rules between Germany and Pakistan. Not until 1968 did an investment treaty include investment arbitration. This was, of course, 3 years after the signing of the ICSID Convention, a framework to resolve disputes, but one which did not contain any rules to regulate investment. So the ICSID Convention was negotiated and signed in 1965. It entered into force in 1966. Some of you might have heard of it, and it's, I think, a fine institution, but in a sense, signing onto the ICSID Convention is a little bit like joining a club. You don't ever have to go to the club. The fact that you're a member of the club means you can go to the club. But in order to have dispute settlement under the ICSID Convention, you actually have to agree to send a particular case to ICSID in a different instrument. And what we see that being done both in contracts and finally in bilateral investment treaties. After 1968, we've seen quite an increase in the number of investment treaties negotiated. You might be a little bit surprised that we don't have precise numbers about how many investment treaties are in force. It probably is in the neighborhood of 3,200. There are about 3,200 treaties and about 2,800 of them are in force. This is a little bit of a sad state of affairs, but there are some countries who don't have a copy of treaties that they are supposed to have signed, and they don't necessarily have records about whether they have been ratified or not. We know about most of the treaties. We don't know about every single treaty. You also have some states that have attempted or have started the denunciation process, but they haven't necessarily followed through. So that also gives rise to a little bit of uncertainty. This last year was the first year that we had more investment treaties denounced than entered into force, than new treaties entering into force. So it does seem that 3,200 might seem like a lot of treaties. It does seem like the negotiation of investment treaties is trailing off. That might be because natural treaty partners are becoming fewer and further between. 3,200 might seem like a large number, but if you do I never can remember if it's a permutation or a combination, but if you count up how many states there are, you could have in the neighborhood of 11,000 bilateral investment treaties. So 3,200 is a lot, but you could have 11,000 in that, and that might make it seem a little bit smaller. And just to kind of come to the the end of the 20th century story on investment, the OECD tried again to negotiate a convention on investment in the 1990s. That was the so-called Multilateral Agreement on Investment, and that negotiation attempt failed. It probably failed for a couple of reasons. It failed in part because this was one of the projects that was undertaken by the OECD, the sort of rich man's club in Paris, and their view was that they would negotiate a text and then they would open it up and others could join. So, we would have the in club would write the text, and then anybody else who wanted to sign on could sign on. And it turned out that people who didn't get to play a part in negotiating the text were not very interested in signing on to the text. It also was at this time that we really saw what I think of as the first, maybe not the first, but if we think back to the Vietnam War, but the first a backlash against globalization. So you had protests in Seattle and Quebec City and Washington, D.C. Against the WTO, and the Multilateral Agreement on Investment was in part a victim of some of that anti-globalization sentiment as well. So if we shift over to the trade regime, the trading regime's approach towards a rules-based legal order occurred in fits and starts, in small steps, during the 45 years or so after the founding of the Gatt and prior to the entry into force of the Uruguay round agreements. Gatt 1947 was not intended to last forever. It's one of the successes of provisional application for more than 40 years. It was to have been replaced by the International Trade Organization, which incidentally would have included investment within its remit. The International Trade Organization would have contained non-binding arbitration and the possibility to refer cases to the International Court of Justice. The United States, which is going to appear as kind of a recurrent villain probably in my story, kind of scuppered that plan, and Gatt 1947 did what could be described as yeoman work for nearly 50 years, supplemented by occasional plurilateral attempts to flesh out some of the disciplines of the various Gatt areas, such as the Subsidies Code and the Anti-Dumping Code. Dispute settlement under the Gatt was based on a kind of jerry-rigged panel system grounded in Gatt Article 23. Hence the continued allegiance to the language of nullification and impairment that we still see today, somewhat to the perplexity of my students, I confess. The panel system was regarded as dispute settlement that was more diplomatic than legal, given the ability of any single Gatt member, including the respondent state, including the losing party, to block adoption of panel reports. Right, so this is not legalized dispute settlement. If you go to court and you lose and you say, oh, well, I'm not going to pay any attention to that, I'm going to block it, well, I don't think the judge did a good job, therefore I think it's a null and void decision, that is not legalized dispute settlement. It was also the case that some countries, in particular powerful countries, felt much more free to block reports than did less powerful countries. But that was the approach in the Gatt until the Uruguay round agreements were finalized in the early 1990s. So you can see that legalization, especially in the trade context, was a little bit slow to get off the ground. This doesn't mean it didn't have powerful proponents. In fact, in the investment arena, we really saw a strong goal to depoliticize dispute settlement. That was one of the mantras of Aaron Brokus and Ibrahim Shihada as they were establishing the ICSID convention. Yet, this depoliticization was done on a bilateral basis because, as I mentioned before, signing onto the ICSID convention meant that this dispute settlement framework was available for use, but it did not mean that it, in fact, would be used. And moreover, the depoliticization, there's always in, I think, international international arena, maybe in any arena, the danger of overselling, right? You say, this is going to be the best thing ever. Here's why it's so good. You tend not to, if anybody's, rented an apartment recently, but they don't emphasize the bad parts of the apartment. They emphasize the good parts of the apartment. They assume you'll find the bad parts on your own. The same is kind of true of any favored policy that any politician, that anyone has. You really emphasize the good parts. So we saw that when the ICSID convention was established, the goal of depoliticizing investment disputes. That depoliticization was really in the dispute settlement method, the removal of the need for an investor's home country to decide whether or not to espouse the claim on behalf of the investor, thereby kind of elevating the dispute into a diplomatic incident between the two countries. It also meant that a neutral decision maker would decide the case rather than a judge grounded in the politics and policies of the host state. Of course, what it did not do was remove the inherently political basis for many of the disputes or the sensitivities they engendered in the host state. That's why I say this was a little bit of an overstatement. Some of you might have heard of the Vattenfall dispute against Germany, where the Swedish company Vattenfall has submitted a claim in ICSID against the Germany's decision to phase out nuclear power. So that's a dispute that's happening in ICSID, in depoliticized dispute settlement. But I saw several of you nodding. The notion that I could suggest that the Vattenfall case is not a politicized dispute is sort of laughable. So there's a limit to the success of legalization and depoliticization. So in some ways, if we go back to the 20th century, we can think of legalization and investment law as somewhat being ahead of trade law, albeit with a bilateral rather than a multilateral reach. From the late 1960s, arbitral tribunals were available to decide disputes under the rules promulgated in those investment treaties, although investment arbitration really did not get off the ground until the late 1990s, 30 years later. On the other hand, dissatisfaction with diplomatic or politicized dispute settlement led the Gatt to take the first step towards greater legalization, which I think of as the next step in the legalization process, something I would call judicialization. So you have more judges, more judging, more judge-like activity. And the Uruguay round agreements ushered judicialization into the trading system in 1995. Not only did the rules themselves become much significantly more detailed and complex, aside from Gatt 1947, which remained as was, but the dispute settlement body was established to oversee dispute settlement. And in particular, the appellate body was established to bring a measure of consistency and control over panel decisions. And of course, the requirement of consensus was reversed, such that only a unanimous agreement of the WTO member states could block the adoption of a panel or appellate body report. Remedies at the WTO reflect the multilateral nature of the organization. Removal of the offending measure is the preferred outcome. Whether or not states actually comply with that requirement is overseen by a rather complex enforcement regime, and certainly individual cases have been the subject of some controversy. But I'll talk about that a little bit more in a few minutes. The dispute settlement understanding itself does not call for a system of precedent. If we think about judicialization, especially those of us who are common lawyers, which I'm guessing most of us are or will be soon enough, we take for granted that you have a hierarchy in courts, and that some courts will issue precedential decisions. They get to control the development of the law and the application of the law. The dispute settlement understanding itself doesn't specify whether appellate body decisions are precedential or not. In practice, however, the appellate body has developed a system of precedent. I note here that judicialization at the WTO is not full-fledged. Transparency is somewhat limited. Hearings are private unless the parties agree. Parties are states here, right? States are the complainant and respondent at the WTO. So they're private unless both the complaining state and the responding state agree. The participation of amici curiae was developed by panels in the appellate body, but in some senses that has never been fully accepted by all of the member states themselves. So again, kind of privacy of the proceedings. And what we've seen now, and as we have built up to this crisis in the WTO, is that some of these practices to really install a judicial approach are precisely what have led to criticisms of the WTO and the appellate body in particular. Now, some criticisms are substantive, while others are more procedural. So one of the main criticisms about the appellate body has been that it engages in overreaching, that allegedly it creates new obligations for WTO members, despite this being forbidden in the WTO agreement. For example, this could include its approach to the United States' famous Byrd Amendment in the to the subsidies agreement, and the anti-dumping agreement with its relationship to zeroing. And if you want to talk about that more in the Q&A, we certainly can. There's concern that the appellate body reviews facts and member state domestic laws de novo. There's concern that it issues extensive obiter dicta, or advisory opinions, that are not necessary and that can cause confusion when used by later parties to justify an argument in a dispute that might otherwise not receive support in the WTO agreements or might not really be right to be heard. Turning to a few procedural issues, the appellate body has waived repeatedly on its own motion the 90-day deadline that it is supposed to meet with respect to issuing decisions. Ex-members of the WTO appellate body continue to hear appeals even after their term has come to an end. So if you've got a case going on and your term comes to an end, the practice has been that you will just continue to hear that case even though you're not still officially on the appellate body. There has allegedly been a presumption of a right to renewal after the expiration of an appellate body member's first term. And of course, as I mentioned, the appellate body statements that its report should be treated as precedent and should be followed. None of these activities seem to be outside the realm of what we expect judicial institutions to do. The United States is the biggest critic of the WTO system, and it has decided to hamstring the WTO process unless it achieves changes. Right now there are 4 appellate body members. 1 term is about to expire, and very soon there will be 3, and 2 of their terms expire in December. So there will be no appellate body members to hear cases. It is worth noting that U.S. frustration with the WTO predates President Trump. We cannot totally blame this on President Trump, which is too bad, but because it's so easy. But even though the United States is the loudest critic of the WTO and perhaps the most important critic, it's not the only critic. If we shift to investment, the current buzz in the investment arena is all about creating a multilateral investment court. In the meantime, in the free trade agreements or in the investment agreements that the EU has negotiated, the EU and its treaty partners have included an investment court system, essentially a mini court for each treaty. In both of these contexts, you would have, none of these are actually operational, but you would have a first instance tribunal, and then you would have an appellate body sitting on top of that tribunal. And the notion is, the European Commission understands that getting a multilateral investment court is going to be a long time coming. So in the interim, they're trying to include these mini investment court systems, which could ultimately merge into the MIC. Now, establishing an appellate body for investment law is not a new idea. ICSID first proposed it in 2004, and the United States has had a placeholder in its treaty since 2003 that it might like to have an appellate body in the investment context. Others, like Professor Yenkong Hodu, in a very good article in the Journal of International Dispute Settlement, have more recently advocated an appellate body for ICSID. Some of these proposals suggest just an appellate body, not both a first instance court and an appellate body. It certainly seems that the time is now particularly ripe for some change to the international investment arbitration regime. Although there's many a slip twixt cup and lip. We don't know if anything is actually going to happen. I mentioned the time frame. Right now, some of you might know that UNCITRAL, the United Nations Committee on International Trade Law, is considering reform of the investor-state dispute settlement mechanism. In fact, there are meetings in New York next week, the 1st of April, to discuss the next stages. After 3 meetings, after 15 days of meetings, the UNCITRAL has concluded that there are problems with investor-state arbitration and that maybe reform is warranted. I think some people here will appreciate this more than others. This is something that has been talked about and written about extensively for 15 or 20 years. But it still took UNCITRAL many, many days to decide that there was actually some kind of problem and then to discuss what the problems were. And that discussion is still ongoing. So now in New York, UNCITRAL is going to start talking about what the potential solutions are, one of which is a MIC, but that's not the only possibility. Given that this is yet another international organization that ordinarily operates by consensus, the best guess is that it will take something between 3 and 5 years to decide, maybe 2 to 3 years to decide on what the appropriate alternative is, with the European Commission pushing very hard for a MIC, and another 2 to 3 years to work out the details of the MIC, assuming that ever happens. That's why nothing is happening very quickly or very soon. And it should be noted that we don't know quite what the CJEU was going to do, which might change everything. But why have a MIC now? And this is where I'm going to hark back to the list of criticisms that I just gave you about the WTO appellate body. Why do we want a MIC? What are some of the justifications? Well, one of the hopes is to bring greater consistency and coherence to investment law. How it can do this, when the idea is that more than 3,000 treaties could feed into one court, and especially how it can do this when those treaties have different provisions in them, is a little bit unclear. I mentioned Professor Hodu's article. I mean, he's right that many of these obligations are found in customary international law and are broadly similar. But I would also argue that some states have very deliberately taken different paths in certain areas. Will a decision of the Multilateral Investment Court be viewed as imposing new or unexpected obligations on states? And that's something, that's one of the criticisms of the appellate body. I think that could very well happen in the MIC context. Investment treaties permit investors to challenge the measures. Measures is usually defined as including laws, regulations, requirements, procedures, or practices, but state measures, government measures, of the states that host their investments. In one very clear sense, that is a review of a member state's law vis-a-vis the state's international obligations. Will a multilateral investment court be viewed as overstepping its bounds when it reviews activities of various host states to determine whether they overstep or whether they violate the investment treaties? Remember, one of the main obligations in investment treaties is the obligation to provide fair and equitable treatment. And often that means, even though it's not reviewing domestic administrative law or domestic law, one of the things you're looking at to see if somebody is treated fairly and equitably is to see if the host state's laws were applied in a way that is consistent, regular with their ordinary practice. So I think it's entirely possible that a MIC could be viewed as overstepping its bounds. This could be particularly problematic in the European Union context, because I'm sure all of you here have still taken European Union law. One of the biggest concerns in the EU legal order is safeguarding the integrity of the EU system and the monopoly of the Court of Justice of the European Union on the interpretation of EU law. CETA and similar treaties. CETA is the Comprehensive Economic and Trade Agreement between Canada and the European Union, and it has one of these international investment court systems in it. That investment court system is not in effect yet because the CJEU has said that the investment court system is a matter of shared competence between the European Union and the member states, and therefore all of the member states have to ratify CETA before that part of CETA goes into effect. So CETA and similar treaties direct tribunals convened under the agreement to treat EU law only as a matter of fact. But you're still going to be addressing, let's say, whether a particular decision of a particular member state, a law, regulation, requirement, procedure, or practice, whether it violates the international agreement, which might mean certainly paying a lot of attention to EU law in the context in which it operates. And in fact, some of the most controversial cases right now, the Spanish solar cases, some of the state aid cases with the former Soviet Union really have to do with the intersection of EU law and international law. And I think entirely likely that certain decisions will lead the European Commission to think that the tribunal is taking too much account of EU law, or taking it upon itself to say what EU law requires and doesn't require. Now I want to say I don't think there's any reason to think that tribunals will overstep their bounds, and I think that practically speaking, these tribunals are not applying EU law, they're applying international law, but EU law is relevant as a factual matter, and the line between application and appreciation of something as a fact or interpretation of an unclear obligation is not always perfectly clear. Thinking about the obiter dicta criticism, people like to talk. Multilateral investment court judges will be people, just like all judges. They will like to talk, and they will sometimes likely talk about things not strictly necessary to render the decision in front of them. So I think there's every reason to think that MIC decisions will contain obiter dicta. Procedural elements might differ. Some of the procedural elements might not draw the same areas of criticism. Although there's talk of deadlines in the multilateral investment court context. Will MIC judges meet deadlines more often than the appellate body? And then finally, thinking about precedent. One of the goals, maybe the biggest goal of the MIC, is to improve consistency and coherence, which would presumably require precedential opinions from an appellate body. Yet the proposals to date, in the individual treaties, which include CETA, the EU-Mexico agreement, the EU-Singapore agreement, and the EU-Vietnam agreement, do not say anything about the appellate body decisions being precedential. Now, this could be because it isn't necessary. In a hierarchical system, precedent is assumed. Yet the WTO appellate body is clearly higher in the hierarchy, yet its authority to issue precedential decisions has been questioned. So I find it a little bit interesting that that none of these proposals so far actually specify that appellate body decisions will be binding. So in short, will we see in 20 years the same criticisms levied against the MIC that we currently see levied against the appellate body in the WTO? it strikes me as entirely possible that we will. And the answer to that question, the real answer to that, might depend on what, for purposes of this talk, I'm calling constitutionalization. Many, including Uli Petersman, have written about constitutionalization in the context of the WTO. And the crux of this agreement is that arbitrary trade policy power should be guarded against by ensuring that individual rights to foreign trade are protected. This means that individuals should be empowered as subjects and beneficiaries of international organizations. While Professor Petersman places some of that responsibility on the domestic judiciary, he would also want international courts to play a role. In fact, his most recent argument on this point has been summarized by Talvi as follows. The independence, impartiality, and due process procedures of national and international courts render multi-level judicial remedies the most principle-oriented constitutional safeguard for interpreting, clarifying, and enforcing international agreements in conformity with principles of justice and human rights. Would a MIC gradually gather more power and authority? Would it hear counterclaims? So would it hear more than just the claim brought by the investor against the state? Would it hear counterclaims by the state against the investor? Would there be any kind of mechanism to override the decisions of the court? Judges and judicial decisions are usually treated, especially by lawyers, as worthy of great respect. We think of courts as the guardians of justice. And will it be the case that this is one of the reasons I think states are a little bit ambivalent about courts and international courts, because the more court-like they are, the more impartial they are, the higher respect their decisions command, the harder it is for a state to criticize those decisions, to ignore those decisions, to say that those decisions shouldn't be binding on them. I think back to I don't know if you followed, and some of you I assume are in investment law, but in the investment law context, you have the cases against Argentina as a result of the Argentine financial crisis, where you had more than 30 cases filed, more than 40, I think about 42 in the end. Many of them settled or were withdrawn, but you've had around 11 go to the merits. And if you've heard about the Argentine cases, what you've probably heard about is the fact that they've taken disparate approaches to the doctrine of necessity, customary international law, and the Article 11 of the U.S.-Argentine BIT, which is the essential security exception. So Argentina has trumpeted over and over again that the legitimacy of investment arbitration is suspect because they have inconsistent decisions about what their obligations are under both the treaty and one of the applicable treaties and under international law. What you haven't heard Argentina say is that in every single one of those cases, Argentina was found to have violated the fair and equitable treatment provision. If you want to find consistency, you could find consistency. I agree that the necessity part of the decision is not consistent. That's true. But it certainly means that Argentina has a good basis for criticizing these decisions because of the inconsistency. I'm not sure, I sometimes think states like that. They don't necessarily want a decision of a highly respected body that they can't say, oh, that's an illegitimate decision. That is not something we have to comply with. That is not something we should be expected to give respect to. So I hate to be cynical on that point, but I think that is sometimes true. You also see even in the investment court system in the individual treaties and in certain U.S. and Canadian treaties, you have a provision that is desired that is included in order to permit the overturning of not of an individual decision, but of the application of a decision in future. So the NAFTA famously includes a provision permitting the Free Trade Commission, which comprises the trade ministers of the NAFTA countries, to issue notes of interpretation of the NAFTA. And those notes of interpretation are binding on tribunals convened under the investment chapter of NAFTA. Now, they've only done this once. They did this in 2001. They issued a note of interpretation about the fair and equitable treatment standard in NAFTA, and also about confidentiality. That decision, that note of interpretation, affected ongoing cases, at least in the view of the NAFTA parties, because it was an interpretation of the treaty. It wasn't amending the treaty, and there was nothing unfair or retroactively applicable about interpreting the treaty. A lot of critics did not find that to be quite so comfortable, because they really thought that it was actually the U.S. and it was, I regret to say, the United States and Canada who were the most likely to benefit from this note of interpretation, where they had persuaded Mexico to issue notes of interpretation in cases currently pending against them and from which they would benefit. So there's always been something a little bit difficult in international law about states being the architects of international law, the main subjects of international law, the main actors and makers of international law. And then when somebody needs to sit in judgment of them, this concern is that they can change the law to suit them, because they, after all, make the laws. And there's always been some tension there. But I think we see this in the trade and investment context as well. So what we see in the European Commission's proposals in the investment court system is to also have a committee on trade and investment, which would be able to issue binding notes of interpretation about the treaty. Now, I have to say that the EU treaties actually say that they wouldn't necessarily apply to existing cases. That would depend on a case-by-case basis. So that seems, a little bit better if that is indeed a problematic part. But how does this fit with constitutionalization? Now, in some ways, this practice could be seen as part of a constitutional system. You have communication between the judicial branch and the legislative or executive branch, and they're talking to each other about what should be the appropriate interpretation of a law. In a constitutional system, a judge can strike down a statute for failure to follow appropriate procedures, or because it was passed without the requisite authority. Parliament can then reenact the statute following the appropriate procedures. But in most systems, Parliament can't do that if the statute is found to be unconstitutional. In most systems, the judge has the last word. It's not clear in international law, I guess in the international law context, whether that is necessarily true, or whether states want that to be true. And in fact, you could say that one of the issues in the dispute settlement body with the WTO and concerns about the appellate body is that the dispute settlement body, the kind of executive branch of the WTO that's supposed to be able to oversee the functioning of the disputes of the appellate body and the panels underneath it, cannot functionally override those decisions because of a lack of agreement among the member states. And that in part this difficulty has led to dissatisfaction with the appellate body. If we shift to the context of a multilateral investment court for a moment, you can see how these committees on trade and investment could work to communicate with judges in the investment court system, in these individual treaties. From a multilateral investment court, it's really difficult to see how that could work, assuming it's a good thing, assuming that that type of communication would be beneficial. Because if you've got states, you don't have 3,000 states, you'd only have a bit more than 100 states, but you wouldn't have an easy, committee as between the European Union and Canada. You would have a committee you would have to have a different I guess, body for each individual dispute. So it's a little unclear whether you could replicate that kind of dialogue between a judicial and a quasi kind of executive or legislative branch, even assuming that were to be desirable. Another, I guess, kind of area of confusion or disparity between like the WTO and investment law is that of remedies. I mentioned that at the WTO, the preferred remedy is removal of the offending measure, a primary remedy, specific performance in the common law. And that's consistent with the multilateral nature of the appellate body, of the WTO, this notion that if that kind of anything you do has multilateral consequences. So that if you have a measure that is violating the WTO system, you might have a complaint from one member state, but there are follow-on concerns for other member states. In contrast, the remedies system in the investment law system have generally been limited to pecuniary remedies. And the notion there is that is less intrusive into the sovereignty of host states. And that's the proposal for the investment court system and presumably for a MIC, that the only authority that tribunal would have would be to order pecuniary damages. And I think that also says something about an ambivalence to giving too much power to this body and some maybe a concern about erosions into sovereignty. So to conclude briefly, I think states are very ambivalent about international dispute settlement because it encroaches on their sovereign prerogative. The more legitimate the international dispute settlement mechanism, the more difficult it is for states to dismiss the decisions. Now, I did describe this relationship between dispute settlement as a minuet, a dance characterized by small steps. Sometimes, of course, these steps can seem rather large. The establishment of a WTO dispute settlement body, right after 45 years of diplomatic dispute settlement, that was a big step. But after a lot of small adjustments. Will states really embrace a multilateral investment court, especially when one thinks of the current state of the WTO? They might, but if they're really paying attention to what's happening at the WTO appellate body, they might be much more likely to refuse to take that next step in their minuet. So I'll stop there and I'm happy to take questions.
Okay, Crichton. Yeah. Crichton.
So thank you for your presentation, Professor. My question is about the appellate body in investment treaty arbitration. So, and in addition to bringing consistency, there are a number of scholars that claim that an appellate body could assist in the defragmentation of international law and subsequently to the integration of human rights law broadly construed with economic considerations. So my question is, to what extent an appellate body in the context of investment treaty arbitration could act as a guardian of fundamental principles and norms? This is an open question because I believe that, for example, in CETA, this is what the signatory parties have attempted to make an appellate body, that could actually deal with issues of law. But in my humble opinion, they have modeled this from WTO law, which has clearly failed to act like that. And this is something that Andrew Lang, for example, pointed out. Yeah. So I want to have your thoughts on this.
So I think that's it's an excellent question. So I think there are several parts to the answer. I think one question really depends on, probably first and foremost, on the text of the applicable agreement. So there might be more of a hope for that in the CETA than in certain maybe more modern treaties than in other treaties. One of the difficulties is that the many of these investment treaties, I think, limit the authority of the tribunals convened under them to deciding whether there has been a breach of the treaty. They do not have a global remit. They're not courts of general jurisdiction. I think that was a deliberate decision to limit their power, which might have been wise, might have been unwise. It might have been a little naive to think that disputes could be so, I guess, narrowed in that particular way. But at least as currently conceived, the MIC, the appellate body, would be receiving appeals from different treaties. And if you've got a treaty like the NAFTA or all of the Canadian and US models, which say the tribunal can consider whether there has been a breach of this treaty, and that's it, I don't know that they have the ability to consider human rights, etc. If you've got a more modern treaty, perhaps like the CETA that says, we want balance, we want to regulate trade, we want all of these balancing things. You might have a more of a hope. You're skeptical. One question, there's some, I think, thought or hope, depending on where you stand, that this could depend on whether who was named to the bench. Who were the decision makers, right? So one of the criticisms of investment arbitration has been that the arbitrators are commercial. They have a commercial mindset. They came from the area of commercial arbitration. They're too business focused. But I have to say I'm a little bit skeptical of that argument, simply because that might have been true back in the day, back in 2000, when things started. But if you look at the top 30 arbitrators right now, you've got, you've got a judge on the International Court of Justice who's a public international law specialist. That's James Crawford. You have Von Lowe, retired professor of international law from Oxford. You have Gabrielle Kaufman-Kohler, professor at the University of Geneva. You have Brigitte Stern, professor at the University of Paris. You have, I could keep going. You have Zachary Douglas, professor at the Graduate Institute. You have Philippe Sands, professor at the University of London. It's not a group of people who are deciding commercial disputes. Like, they have, even the ones who are viewed as more commercial have a very varied background. So Charlie Brower, who is always viewed as an investor's arbitrator. And certainly he was in private practice for a long time, but he was legal advisor at the US Department of State. Like, he has public international law backing. E. Fortier, whose chair I hold, for whom my chair is named, yes, he was chairman of Rio Tinto Alcan. He was managing partner of what was then Ogilvy Hano and is now Norton Rose Fulbright. There's been a merger. Ogilvy Hano was smaller, but he was also Canada's ambassador to the United Nations during the first Gulf War. He was also this might resonate here a little bit with some of you. He also argued the Quebec sovereignty referendum in front of the Canadian Supreme Court on behalf of the federal government of Canada, even though his name is Yves Fortier and he's a Quebecer. So people are much more complicated and have a very varied background. And I think it states hope that they can put people on this bench that decide things in the right way. I'm a little skeptical about what the right way is. I think most of the cases are extremely fact dependent and not very easy to decide. I'm also not sure that we can in the abstract know, and we think about that for judges generally, we don't know how they're going to decide. If we knew how they were going to decide, we wouldn't have a case. We wouldn't have anything to we would be all out of business. So I mean, we would, but we wouldn't know what they were going to do. So I'm not sure. I guess, like you, I'm a little bit skeptical, maybe for slightly different reasons. But yeah, I don't know.
Well, to be honest, just a follow-up question. I have to be I'm extremely skeptical because I believe that the biggest problem in investment dispute is that there is no, this is in general PIL realization that there is no hierarchy in international law, and apart from some Hugo-Hogan's norms, everything is relative. And I believe that the biggest problem is that, for example, in the text of CETA, there is no provision or mechanism whatsoever regulating what is the relationship between an investment application and what should the tribunal do when the state decides to intervene with investor rights because they are trying to regulate an environmental issue. So I think this is the biggest problem. It's not so much about the applicable law, but but mostly about the lack of mechanism and provisions regulating the relationship between competing obligations.
Well, I mean, I think that's really linked. I mean, you're saying there is no, like, you're directed, you decide whether, I don't know, you're, walking down the street and you get run over by a car and you decide whether that car driver was liable for negligence. You're not deciding, that's the only job you have. Like, if you're told, there's an agreement, this is all you can decide, and you say, oh, but we needed to know all of these other things, and you say, nope, we are not allowed to know those things. That's why I think there's a relationship with the applicable law. That you're not deciding whether there's a breach of contract if your remit is limited to tort law. And that might be a mistake, but that's part of it. That's why I think they are
definitely interrelated.
And the other thing, this is a little bit more fact specific and maybe a little bit more policy oriented, but I also think I think all of these kind of human rights, environmental issues are made more complex by the fact that the host state is also responsible. Like, I'm not opposed to imposing obligations on investors to honor human rights. And certainly I think they should honor environmental laws, but I think that host state also has to honor its human rights obligations, also has to ensure that its environmental laws are being followed. And in a lot of the cases, I'm going to say there's kind of joint and several liability there, and that's a problem. That's a bigger problem, right?
Okay, thank you. That was actually, by the way, a PhD student, Crichton. So, you should have introduced yourself. That's fine. Yes, Javier.
Yes, thank you very much. Thoroughly enjoyed the presentation. I thought it was absolutely brilliant. I have a question or a comment to make because obviously, and I do apologize in advance because I'm a domestic lawyer rather than an international, and maybe but just a reflection, obviously. As an academic in the UK, in which obviously, as you clearly know, the judiciary are not entitled to strike down legislation, and their role is more limited, as you were referring to in your presentation. By comparison with the civil law jurisdiction where I grew up and where the judges are entitled to strike down statutes and saying this act is not compatible with our constitutions. In any event, in either case, I think what brings them together, both jurisdictions, is obviously the role of the judiciary is really, really important, and obviously they uphold democratic values and they're very, very socially respected, I would argue, generally speaking. Therefore, when it comes to this whole idea of this constitutional order, even though I would like to know your opinion, but because even though I obviously share with you your reservations and obviously the reluctance on the part of the states in order to recognize this extra layer of legitimacy to the international orders. But I wonder whether at times this lack of legitimacy that sometimes is argued about the international order could certainly be addressed by a much stronger judicial order, because that works in the domestic arena. If we're talking about this international constitutional setting, I think we need a much stronger judiciary.
I am with you. As I say, I'm not quite sure that's what states want, just precisely because it would be a much stronger judiciary, a much stronger order, and much harder to contravene, right? appreciate and am not really sure how to get around the kind of democratic legitimacy accountability concerns. And I see that I'm going to say the traditional order, the notion that the state represents you, and the state chose the judge, therefore you're represented, has somewhat broken down. That I think people are skeptical about, in a way, internal governance. I'm speaking about things we were talking about earlier, but that people are somewhat skeptical of, their internal governance. Do their MPs represent them? Does the government, does Parliament represent them, et cetera? And therefore, when you attenuate that and you say, well, Parliament has decided that it would be good to have CETA, and it would be good that this is the person that would be good to appoint to the CETA court, you really have a breakdown of trust in that regime. So I'm not sure how to, if on top of that you have the state itself saying, oh, I'm not sure we have much faith in these international judges, I don't know how you make that stronger. Like that's a real conundrum. And we see, the WTO, because I'm an international economic lawyer, it's easy to talk about the WTO and investment law, and those are maybe two of the hottest areas right now. But there's the International Criminal Court. I don't know if anybody here is familiar with the ICC, but the ICC is having a real crisis right now as well. I think there's a real lack of faith in kind of international institutions, maybe more generally, but including international court institutions. And I wish I knew how to remedy that. But my fear is that states, who are probably the only actors who can remedy that, don't necessarily want to.
Okay, your name, please. And
Yes, I'm also a PhD first year. So thank you for your presentations. I have a few questions to ask you. The first question is about the relationship between trade and investment. So as of now, I think there's a lot of the FTA or RTA that they also include some provisions about the investment in that. So I just want to know, in your opinion, so do you think that should we put investment separately from trade, or we can make it together and submit it to the, for example, the Treaty or something? My second question is about something similar to the multilateral investment court, but I think formally we also have something called the ITI, International Tribunal for Investment, that is established by the Mauritius Conventions. Okay, I know that it's not about the transparency, but do you think that is also is the same idea with from the CETA or the MIG one? And also my last question is about MIG. I just want to know that so MIG is like a permanent organ, a permanent body of the court. So it will make have a lot of things to do, like the cost, the standing body, the place, and a lot of things going on. So I'm not sure whether there's enough case to feed to the cost in this year. So thank you.
So you're not sure there are enough cases, is that right?
Yes.
Yeah.
Okay. Do you mean cases to make?
Yeah.
Or
Yeah, cases
okay.
to make, yes.
Okay. Do you want to take it? Yeah.
Yeah, so let me try. So the first question, should trade and investment be treated together? I take this to be, should the WTO expand its remit to include investment? Wouldn't it just be simpler to kind of add investment to the WTO instead of continuing to treat it separately? In some ways, yes. The problem there, and here I just can't get around the politics of it, that hardly anybody at the WTO wants that. And I think developing countries in particular don't really want that. Given the current situation at the WTO, I'm not sure that even the people who used to want that continue to want that. So in an ideal sense, sure, I think that would be more convenient, that would be more reasonable. I think that there are some arguments that you see, like in a free trade agreement, the investment chapter is a very small piece of the trade agreement. and probably one of the least important pieces of the trade agreement. And if you actually merged investment in a full-fledged way into the WTO, then you would maybe see some of the lightning rod focus and criticism of investment fall away, and you could maybe see some of the synergies in benefits as between those two entities, between those two kind of fields. But I think that is so far from happening, and in fact the only place it seems likely to happen, if at all, is in one of these plurilateral groups that are considering kind of trade facilitation, and I think that seems likely to undermine the WTO, one of the benefits of which was to try to put everything onto a level playing field in 1995. Second question, I'm not sure I don't know what you're talking about when you talk about the International Tribunal, but if the Mauritius Convention is the mechanism to make transparency obligations applicable to existing treaties. So the idea is, so we have these 3,200 treaties, most of which don't say anything about transparency. And the goal is, well, a goal of some people, I should say, is to try to make it so that investment disputes heard under those treaties would be heard under kind of more recent transparency rules. So if a state signs the Mauritius Convention, and if their bilateral investment treaty counterparty also signs the Mauritius Convention, then that means that the disputes decided under their treaty will be heard under the transparency rules. This is a great idea. The problem is that most states, and only 5 states, have ratified the Mauritius Convention. So it hasn't proved very effective. It's been open for ratification since 2014. So this is a mechanism, and probably is the same mechanism that one would use to establish a MIC, a multilateral investment court, for these current treaties. And yes, I think that could work, assuming people ratify it, but that's going to take, obviously that's going to take even longer. And maybe that goes back to the point I was making about states. There's a lot of criticism about investment arbitration that it isn't more transparent. But I have to say, one of the reasons for that is that states don't want it to be more transparent. Many states. So if states want it to be transparent, they could have it be transparent, and they're not really racing to sign on to the Mauritius Convention. And finally, the MIC, will there be enough business under the MIC? No one knows, but I take that, the same is true under these individual investment court systems. And this is one of the stumbling blocks that we're gonna have to establishing any kind of MIC, is how do you fund it? Who is gonna fund it? Who is gonna pay for it? Because international tribunals tend to be expensive, they can be expensive, and if they're not even going to hear a lot of cases, is it worth having them? So you hear about this, I'm not, some of you might know the numbers better than I do, but I believe that the International Criminal Court's budget the International Criminal Court has spent $90 million, and they've tried, 6 people? So a lot of people think that's not a very good return on investment. Now, I don't think that even though people think that investment cases are extremely expensive, and they are, a court would probably be a little bit cheaper than the average case, but would still have to be funded. So I don't know if they'd have enough business. There's also kind of the corollary question, whether investors are going to have enough confidence in a MIC that they even think it's worthwhile to bring cases. Now, I have a lot of faith in my fellow lawyers, and I expect if there's a mechanism, a tribunal, they will come. But that is, something of a concern. And I don't, if the European Commission were to say, we'll put up $100 million for the first 10 years, we want everybody to sign on, you won't have to pay anything, would they get some takers? They might. that does not seem likely to happen. There's no indication that they want to do that. Short of that, how is this going to be funded? How is it going to be funded? And I think very closely related to that is this, is ça vaut la peine? Is it worth it? If you're not going to have enough people using it, it's not going to be worth it to fund it. Will anybody take the leap of faith to kind of fund it in case there aren't enough people using it? I mentioned in my talk that we have had investment arbitration included in investment treaties since 1968. The first case wasn't brought under an investment treaty until the late 1980s. And it really did not start going until the late 1990s, even the early 2000s. So when I was young, back in the day, when I was starting working on investment cases, especially those of you who are working in this area, there was like nothing. There was nothing to read. There were no decisions to read. There was no argument about precedent because there was nothing to be precedent. We did the first edition of our NAFTA book, and we're like, it can't take very long. There are only like 6 cases. This will be a piece of cake. And now, of course, we're in a completely different boat. But it's interesting to see how fast that has changed. Will a MIC, do the same thing? Maybe. So much depends on how it's designed, what judges are put on it, what kinds of, what kinds of procedures there are, and the like. It's really hard. It's really hard to know. But as I say, I have confidence in my fellow lawyers.
Okay, thank you very much. We have one last question now, and then we'll have to, I know you have a lot of questions, but you can ask in the bilateral, because we have a reception that should have started at 6 o'clock.
Oh.
So very briefly, please, yes.
I'm an LLM student in International Business and Commercial Law. Excuse me, I just wanted to be late. You mentioned at the end of your presentation that between human rights and investments, the whole state should take more responsibility. The issue is following, in my view. If the investors, the foreign investors, make breach of the human rights, if the host states act to protect the human rights, it could be a breach of the investment law, on one hand. If the state is passive, it will be breach proceeding with the acting with the investor, which make him actually vulnerable to its own citizen, which can make a claim to the foreign investor as well as of the passivity of its own state, which should protect the public interest of its citizens. Therefore, I'm just asking about which options will stay for the host states. On one state, if he acts, it will be breach of the investment law. If he does not act, it will be violation of the human rights. Because if he acts to protect the human rights in the view of international arbitration courts, most of the cases they decided that it's a breach of investment law, that it should define the way in which human rights as well as the investment law is protected. But actually it's not the case, because the investors have the higher degree of investment protection, but actually they came with the lower degree of the human rights. Treaties are between states, not between physical individual persons. The investor take the higher degree of its home states which come, but regarding its responsibility of the human rights, it has not any.
So is it a question?
Yeah, it's a question.
Okay, so what's your question?
Of the host state, because it's already closed.
So I actually don't agree with your premise. I don't agree that it is always the case that the state has to decide between its...
Should we not look to the highest standard of his home states on the human rights? Depending on his...
I don't understand that part of the question. I'm sorry, I don't... Higher standards of whose home state? I don't understand.
Investors from developing country go in developing country and make investment. They have low degree of the human rights, and he made violation. In his home states, he enjoyed a high degree of protection of human rights. But in the states of his investments, he does not protect the human rights.
Right. Okay, so I think states are primarily responsible for protecting human rights. I think in most cases, if a state acts to protect the human rights of its citizens, it will not be found to have breached an investment agreement. I agree that there could be a few cases when that is not true, but in most cases, I think it is true. The states win more than half of the cases. Most of the cases don't involve human rights violations. So I think a state that is truly wanting to protect human rights can act to protect human rights, and they will not be found to have violated the investment agreement so long as they are truly acting to protect human rights.
Okay, thank you very much. Please, can we...